Thank you for joining us for this quarter's Compliance Bootcamp webinar, HIPAA and Mental Health Compliance. Please note the presentation slides will be emailed to all participants by tomorrow. At the bottom of your screen, you'll see several widgets for your use during the presentation. For example, if you have a question, please click the purple Q&A icon to the left. You will also be able to download your SHRM and HRCI credits at the conclusion. Speaking today is Dan Cooperstein, Senior Vice President of Compliance at Corporate Synergies. Corporate Synergies is a national insurance and employee benefits brokerage and consultancy where Dan is a respected thought leader on healthcare reform. He has published many articles and videos on the Affordable Care Act and other laws and regulations, which can be found in the Knowledge Center on corpsyn.com. At this time, I will turn it over to Dan.
Great, thanks, Dina, and welcome to today's webinar on HIPAA and mental health compliance. The things we want, first before I get started, I just wanted to briefly mention that I'm presenting to you live today from our New York City office, which is right in the heart of Rockefeller Center. So if you hear any honking or sirens, please excuse that, and we'll just try to move on with the presentation. So we're going to first start out with just a very brief update and recap of some of the most significant recent health and welfare plan compliance-related developments that have happened in the last quarter since our last webinar. And then we're going to jump right in to our top 5 HIPAA and mental health developments to discuss. And while we touched on some of this material in the last quarter, this quarter we're going to take a much deeper dive and zoom in on more of the facts of the big penalty cases, and then talk much more about the things that your organization can do as a plan sponsor to protect itself from HIPAA breaches, whether they're caused by a cyber attack or a phishing incident or something else. So that's going to be really the focus for today's presentation. So let's go ahead and get started with our very brief health and welfare plan compliance update. And I want to mention that a lot really did happen in the last couple of months since our last webinar. And many of these things may not necessarily be complete game changers for your organization's health plan and insurance arrangements. They're not just noise. They're going to have a really direct impact on the costs and liabilities associated with your plan. Everything from tax reform to changes in regulations about HRAs. So let's take a closer look at all of this stuff. So one of the big things that got a lot of media attention, probably the most media attention of all of the developments that happened, was the executive order that President Trump signed on October 12th. And really the key thing to note here is that this doesn't really change the law. Actually, it does not change the law at all. It just directs the agencies to take actions to change regulations, to change rules about the Affordable Care Act. And the 3 main areas that were changed, that were proposed to be changed as a result of this executive order, were dealt with health reimbursement arrangements, association health plans, and short-term coverage, short-term limited duration insurance, which is commonly referred to as short-term coverage. And let's start with association health plans, since that's an area that is of a lot of concern to a lot of our clients out there. First of all, what are association health plans? Well, they're basically just when a group of employers get together, typically smaller employers, they get together and they pool their risks together to all join into one health plan. There needs to be some element of commonality of interest, or some element of a shared industry and some commonality between the different employers to have an association health plan. But this is an area where the Trump administration, they want to make it a lot easier for small groups to join these association health plans. In fact, this executive order directs the Secretary of Labor to, within 60 days, consider expanding the rules for AHPs and make them easier for employers to join. Now, why would the president want to do this, right? Well, the first thing, of course, the major reason why this would happen, of course, is because the president is concerned about the small group rules, the rules that require community rating, and add a lot of cost to small employer health plans. By making it easier for them to join together in association health plans, they can avoid a lot of these difficult regulatory requirements in the small group market, and their costs go down. So that's one initiative in the executive order. The other big thing that was proposed with respect to employer-sponsored coverage was the changes to the rules on HRAs. In the order, the president directed the tri-agencies, the Department of Labor, Treasury, and HHS, to, within 120 days, consider proposing rules or revising existing guidance to increase the usability of HRAs, expand employers' ability to offer them, and allow them to be offered in conjunction with non-group coverage. Now, just to provide a little background here, when the ACA became law, the Affordable Care Act, it said you have to have an HRA your HRA has to be integrated with your major medical plan. So if you have a group health plan, the HRA has to be a part of it. It can't replace it. And one of those things that was a big additional prohibition on employers that came out with the ACA was that it said HRAs cannot reimburse individual premiums in the individual market or on the exchanges. So these new rules, at least the way it was written in the order, the executive order seems to be suggesting that rules should be drafted or guidance should be revised to change these ACA rules and make them more flexible to allow HRAs to reimburse individual premiums and do things like that. Now, one thing that did happen before this executive order, at the end of the Obama administration, is that there was a law called the 21st Century Cures Act that allowed for small employers to do what are called Qualified Small Employer HRAs, or QSERAs. QSERAs are a way that small employers can reimburse individual premiums in the individual market or on the exchanges. And, so there is some flexibility there that happened at the end of the Obama administration. But we were expecting, as a result of this executive order, that the agencies might do something very dramatic or radical to change the rules there, and they did not. There was guidance that was issued on October 31st that really just kind of did more to clarify the existing rules for QSERAs, and it really didn't do much to really change the law with respect to HRAs. The other thing I'll just mention very briefly, since it doesn't have a real big impact on employer-sponsored coverage, is that the executive order also wanted to change the rules on short-term coverage, and that's coverage that is allowed to be purchased to cover individuals who may be between jobs or who may need insurance for a short period of time. And it was originally, before the ACA, it was allowed to last for a longer period of time. And after the ACA, it was cut down to a much shorter period of time. And the goal of the executive order is to expand the length of time that people can use the short-term limited duration insurance without facing an ACA individual mandate penalty. So that's another part in there. It really deals more with individuals, not so much employers, but I thought I would mention that as well. And so what are the key takeaways here for plan sponsors? Well, the big thing to take away here is that the White House and the Department of Health and Human Services are really going forward full force on trying to change the way that the ACA is enforced and the way that it works, really because of the fact that they couldn't get something through with Congress, right? We all know, from our last webinar and the webinar before it, where we took a closer look at what was happening with the Repeal and Replace initiative, that it just simply didn't work, right? So now it looks like the administration is trying very, very hard to work with HHS to try to change the ACA rules from the inside out. Okay, let's talk about some of these other big compliance developments that happened recently. On October 6th, two new regulations actually came out on the ACA's contraceptive coverage mandate. And what these two new regulations do is they expand the exception and allow more employers to qualify for an exception to the rules. And just to kind of give a little bit of background here, it's something we talked about in earlier webinars. This really resulted from the May 4th executive order, where the president said he wants to do something about moral conscience and try to make it easier for employers that have religious objections to the contraceptive coverage mandate to get exceptions. So here's what it does, right? The two new regulations, they eliminate the existing ACA procedure for obtaining a waiver to the contraceptive coverage mandate, and employers can claim an exemption either based on sincerely held religious beliefs or sincerely held moral convictions. And pretty much any employer, you don't have to be a church, you don't have to be a church-related organization like a church school or something like that. Pretty much any different type of employer out there can claim one of these exemptions. The only ones that can't are if you are a publicly traded company, you can't claim an exemption based on moral conviction. But they've really pretty much opened up this exemption extremely broadly. In fact, Notre Dame announced on November 2nd that it will be ending its contraceptive coverage at the end of the 2017 plan year. So this thing is going to really kind of got much bigger. Another thing to note is that exempt employers will no longer have to file their notice of exempt status. So he's really just made it a lot easier for employers to get around this ACA mandate. We should also mention on October 12th, the President terminated the ACA cost-sharing reduction payments, or CSR payments, that were paid from the government to insurance companies to help make coverage more affordable, to subsidize the cost of coverage on the ACA exchanges. And just to provide a little bit of background here on the CSR payments, these things were, there was a lot of litigation about whether or not they were truly constitutional because they were approved by President Obama without a congressional approval. So there's a lot of back and forth as to whether or not the president was actually going to terminate these payments. And since he did, the result, of course, is that there's going to be a lot less money going to insurance companies to subsidize the cost of insurance on the exchanges. Now, these particular subsidies were tied to the silver plans on the exchanges, so that coverage is going to become much more expensive as a result. Now, for those individuals who are low income, this is not going to have a direct impact on them because they'll be able to qualify for a larger premium tax credit. But for those individuals, generally speaking, that make $48,000 or more that are on the exchanges, it's going to become much more expensive for them to get a silver plan on the exchanges. So if you are an employer that's concerned about this because you have a lot of employees who are getting coverage on the exchanges, you may want to tell them, look, you should definitely explore the gold plans and the bronze plans and the other plans, outside of the silver plans. Maybe you can get something for a much lower cost than what you're seeing for those silver plans. We should also just briefly mention something we've talked about in earlier presentations, which is that those new exchange rule modifications finally went into effect for the 2018 year. They've shortened the open enrollment period. They've required additional documentation to get a special enrollment on the exchange. And there's been some other changes as well. There's a change to the guaranteed availability rules, which basically means that if you're an individual, you want to buy insurance coverage on the exchange, and you didn't pay the insurance company last year for the insurance and you never paid them, that insurance company can require that you pay them back before you can get new insurance coverage for 2018 on the exchange. So a lot of new rules were added here. And the thing about that, of course, is that you can still kind of get around it by switching insurers, but all of these things were, of course, designed. There were some other rules as well we don't have time to discuss today, changes to actuarial value requirements, network adequacy, and essential community provider rules on the exchanges. We're not going to really have time to go into all of that today, a lot of technical details there, but bottom line here is that it's become much harder for individuals who may have been trying to game the system on the exchanges to do that in 2018. Okay, another thing that happened was that on October 12th, the DOL proposed a 90-day delay in the effective date of the final disability claims regulations, which are scheduled to apply to disability claims that are filed on or after January 1 of 2018. And what this did was really that, these proposed rules would have applied rules similar to the rules under the ACA that apply to medical claims, would have applied those claims to disability claims in your plan. The primary impact there, of course, would have been on the insurance companies to change those rules. But, of course, liability can always be, be put onto the employer there for a self-insured plan. So you definitely want to be very careful and make sure that you're doing the right thing when that probably does change on after April 1st, 2018. We should also mention the change to the San Francisco Office of Labor Standards. They created a new change to the healthcare ordinance in San Francisco. And of course, these were new rules, final revised rules that came out on September 26th that became effective on October 29th. And why is this so important? I mean, I think it's kind of, we don't normally talk about things that are happening really at the local level, but this is really very important because any employer with operations in San Francisco is subject to this. If you have a lot of employees working in the city of San Francisco, this is not exempt under ERISA, so you have to comply with it regardless of whether or not you have a fully insured plan or self-insured plan. And why are these rules? What happened with these new rules? Well, they basically made it a lot harder to self-insure the benefit and add a lot of new complexity to things. While employers who offer uniform plans can still use a self-insured health plan to satisfy the employer spending requirement in the rules, they're now faced with very large practical problems. Self-insured plans are required to either irrevocably pay premiums to a third-party provider, where no portion of which may return to the employer, or alternatively pay claims as they're incurred and determine that the average hourly expenditure for the preceding year meets or exceeds the current year expenditure rate. And unfortunately, when they're determining the average hourly expenditure, employers are now prohibited under these new rules from using a COBRA rate, and amounts have to be irrevocably spent and reflect amounts irrevocably paid to third parties. So a lot of changes there to the irrevocability rules. These rules were based on a concern that self-insured plans were not actually spending the required amount that they should have been spending on employees. So a lot of complexity there. We would hope that the Labor Standards Office issues some clarifying guidance or exceptions to make this a little bit easier on the self-insured plans. Okay, we're briefly going to talk about tax reform. There's been a lot of news out there. In tax reform. What we did here was just kind of highlight some of the things that happened in the first House bill that came out on November 2nd before the amendments and changes in the Senate bill and everything else. So this just kind of gives you some of the major changes that were proposed for health and welfare plans in that initial bill that came out on November 2nd. And we'll talk about some of the things that changed as I go through this. But one of the big things that would impact us, as consultants on health and welfare plans, is that the new bill would repeal the income tax exclusion for employer-sponsored dependent care assistance plans, or DCAPs. Now, there was an amendment called the Brady Amendment that came out subsequently that would extend the DCAP tax benefit through December 31st of 2022. So you do have a little bit more time there if you still want to have kids and you're planning on it. You still have that tax relief for a little bit. It would also, the new bill, the House bill, would eliminate the deduction for contributions to Archer medical savings accounts. It would repeal the exclusion for employer-sponsored adoption assistance programs. It would repeal the exclusion for employee achievement awards. It would eliminate the employer deduction for tuition reimbursement benefits. It would repeal the deduction for moving expenses and the exclusion for qualified moving expense reimbursements. It would repeal the deduction for membership dues and on-premises athletic facility expenses, qualified transportation, fringe benefit, and parking facilities. But two things in there that were expected that were expected to be in the bill that were not in the original bill when it came out was that there was no cap that was imposed on the employer exclusion for employer-sponsored health insurance coverage. That was expected and was in there. And there were also no changes to the Cadillac tax. There was, however, a change to the ACA individual mandate that came later when the Senate bill came out. It wasn't in the initial Senate bill. It was a change that happened 2 days ago. Senate lawmakers announced that they will be cutting the ACA individual mandate tax as a part of the tax reform bill. So big development there. Lots of developments happening there. They're changing as we speak. Obviously, if there's anything very significant, we will be updating you on our ACA Now page. As it applies to health and welfare plans. Okay. Now, there was one very, very important and significant development that happened very recently. On November 2nd, the IRS quietly announced that it was going to be finally penalizing employers for their 2015 calendar year if they didn't comply with the ACA pay-or-play rules. Now, if you remember, those are the rules that can be assessed against employers that either do not offer health insurance coverage at all, or even if they do offer coverage, but the coverage is not affordable or does not provide minimum value, they can still be assessed one of these pay-or-play penalties. Now, there's been a lot of talk for years, since this rule first went into effect in 2015, as to when this, how this was going to work, how the penalties would be assessed, how would employers, appeal those things, and and this new revised Q&A guidance explains what those IRS procedures are going to be. And we don't have time to go in a lot of detail into all of those things today and how you appeal and everything else. But essentially, the IRS is going to be issuing, if your organization was liable for any month in 2015, then before the end of this year, before they said in late 2017, the IRS will be issuing your organization what's called a Letter 226J, which will inform you of what your liability exposure is. You will then have 30 days to respond to the Letter 226J. You can also request a pre-assessment conference. There's other things that you can do. All of that stuff was outlined on our ACA Now page. We had a really good article about that. We also did an e-alert for our clients about that. But obviously, if you have any questions, definitely feel free to give us a call if you're concerned about that. One thing to be wary of, especially if you're a very large organization, is that if you get one of those, if you're a very large organization, it could take more than a week for you to get that Letter 226J into the hands of the right person. So you really want to be on the lookout for those and make sure that as soon as you get it, it's being put in the hands of the right person. Okay, so now I think it's time for our brief refresher course on HIPAA and mental health parity rules, because this is really going to be the focus for today. So we thought we'd just take a short amount of time to kind of go through the basics and review what do you need to know when it comes to HIPAA and mental health parity. So let's start with HIPAA. Who has to comply with HIPAA? Well, health plans, health insurers, individuals or group health plans that provide or pay the cost of medical care, healthcare providers, healthcare clearinghouses, and business associates are also required to comply. And business associates are defined as an external, non-affiliated third party that provides services or assistance to a covered entity that involves the transfer of protected health information, or PHI, which we'll be defining in just a little bit. Now, business associate agreements, generally, these are the entities that are serving, vendors or service providers for your plan. So, when it comes to your business associates, you need to have what's called a BAA, a business associate agreement. And in the BAA, that includes, contract provisions designed to define the boundaries of liability and limit the access of PHI between the plan and the business associates. Also, under these rules, subcontractors have to comply as well. So if there's a vendor to the vendor, that's vendor working for the vendor, they also have to sign onto the BAA or do a BAA subcontractor agreement. So let's talk about protected health information. What is it? Well, it's defined as individually identifiable health information that's created, transmitted, or maintained in any form. It can be electronic, paper, or oral, related to past, present, or future physical or mental health, or provisions of health care, past, present, or future payment for health care, or data for which there's a reasonable basis to believe that an individual can be identified. So very broad definition relating to any kind of health care, past, present, or future, and has to be individually identifiable. And it also includes ePHI, which is PHI created, received, stored, or transmitted in electronic media, such as in your iPhone. And the classic example there is if you take a picture, if you come out of the doctor's office, I like to give the example of one that people probably don't think about, which is that if you come out of the doctor's office and you just broke your leg and you just got a cast on, you take a picture of your new cast showing your broken leg, and then you send a Snapchat of it to your friends in the workplace, or just in general. You're sending you may not realize it because it's Snapchat and it's electronic and it's going to disappear. But technically, you are transmitting individually identifiable information about a physical health condition that occurred, an incident that happened, the broken leg. So it meets all of those definitions, even though it's very transitory and it's electronic. So it's just something to be very careful about. Okay, so we talked about what it is, right? What is not information that would be covered under HIPAA? Well, if the health information is not identifiable, if it's held by non-covered entities, so if it's not one of those entities we talked about that's a covered entity, and also employment records with health information held in the entity's role as an employer, but not in its role as part of the group health plan. So, for an example, if you're an employer requiring medical certification for a period of sick leave, that information disclosed to the employer for purposes of, whether the employee qualifies for sick leave, that's not going to be considered to be PHI. But if you're an employer that sponsors a health FSA and you process the health FSA claims yourself and the same employee submits receipts of the health FSA for medical expenses related to the same condition that required the sick leave, then that same information, that same health information contained in the receipts would be PHI because it's submitted to the employer for a plan administration function, which is the function of processing the health FSA claim. So, same information, but depending on the circumstances, it can change it from PHI to not PHI. Okay, so let's talk about a breach, which is the big, hot topic right now. We've heard so much about these cybersecurity things happening in the news. Equifax, it's even, it's become a really hot topic. So what happens? How is a breach defined under HIPAA? Well, it occurs when there's an unauthorized acquisition, access, use, or disclosure of ePHI, and the below requirements are met. So all these things on the slide, information is considered to be unsecure. Information was used or disclosed in an unauthorized manner. An impermissible use or disclosure of PHI is presumed to be a breach unless the covered entity or business associate demonstrates that there is a low probability that the PHI has been compromised, taking a look at all the different, factors and circumstances that could have occurred. And fourth, the use or disclosure that, the alleged breach does not fall under one of the exceptions as listed in the statute, and those are an exception for unintentional access, use or disclosure, inadvertent disclosure by a PHI handler, or the good faith belief that the unauthorized person was not able to retain the PHI. And so as an example of that third one, if let's say, I took a picture of my broken leg, I got into my car and I waved my iPhone with the picture, on the iPhone outside my window of my car as I drove by an office, maybe 20 feet from the windows of the office. I think you could say there's especially if I was driving pretty quickly, I think you could say there's a good faith belief that there was no unauthorized person who was able to retain the PHI. So you have to really look at all the facts and circumstances when making the determination of whether or not a breach occurred. Under the statute, the notice has to be provided within 60. Notice of a breach has to be provided within 60 calendar days after its discovery. Notice has to be provided to the impacted individual, the Department of Health and Human Services. If it involves more than 500 individuals, then you have to notify them immediately. If it's less than 500 individuals, you can log the breach on the HHS website. That can be done on an annual basis. You have to notify the media if the breach involves more than 500 individuals in the state or jurisdiction. The business associate is required to notify the covered entity. And in fact, we should mention that when it comes to penalties, the business associate, there were new regulations that came, not so new anymore, on January 25th, 2013, that came out back then that applied civil monetary penalties to business associates. So the penalties, it doesn't just extend to the covered entity, it can be applied to business associates as well. And what are some of the sanctions for not complying with the HIPAA rules as amended by the high-tech law? Well, increased audits can occur. I think if you've been penalized once, you're probably going to be under more scrutiny again by the Department of Health and Human Services, and they have a enforcement division, the Office of Civil Rights, OCR. They're going to come in and be watching you much more closely. Penalties can be assessed that are much higher for willful neglect. So in other words, if you've been assessed once, you can, if you ever get assessed again, they're probably going to say, well, you willfully neglected doing the right thing. Also, state attorneys general can sue. They can file a civil action for violations on behalf of residents of a state. So that's another thing that can happen as a result of noncompliance with HIPAA. And here we've shown how the penalties are actually assessed for 2017 numbers. And you can see that they're assessed in 4 tiers depending on the level of intent of the employer, and that's per violation. So, for example, if the entity is not aware of the violation, then the lowest per violation per incident penalty is $112 per violation. But on the other hand, if there has been willful neglect, and it hasn't been corrected in 30 days, then the penalty is $55,000. The lowest penalty under Tier 4 is $55,910 per violation, and then there is a max or cap for all violations of an identical provision within a calendar year, and that is a penalty not to exceed $1,677,299. So very high penalties can be imposed, and this is just sort of the helpful chart showing you kind of how those penalties have been adjusted upward. The numbers you see on the top, that shows the penalties that were prior to 2016, and then the Department of Health and Human Services started to adjust those upwards. So in 2016 and 2017 they went up, and the numbers you see at the bottom in the parentheses, those are the 2017 penalty amounts. Okay, so let's talk about mental health parity. This has become increasingly an area of a lot of concern for employers, particularly with the opioid epidemic that is happening in this country and the very high costs of treatment centers, and just with the high cost of mental health benefits and plans today, people want to do things to change the mental health benefits in their plans, and they need to be aware of the mental health parity rules. So what are these rules? Well, they apply to both the plan sponsors and to the health insurance companies, the issuers, and the general rule is that a group health plan that provides medical or surgical benefits, and it also provides mental health or substance use disorder benefits, it can be subject to rules under both what's called the Mental Health Parity Act, or MHPA, or MEPA, and the Mental Health Parity and Addiction Equity Act, or MEPIA. And there's three main mandates under each of those laws. The first is that if they're going to be, the first one is really kind of a pretty narrow rule in the post-ACA world. But the first rule says annual or lifetime dollar limits for medical or surgical benefits must generally apply those same or higher dollar limits for mental health benefits and substance use disorder benefits. Now, this rule has such limited application because the ACA said that the ACA said that you cannot apply annual or lifetime dollar limits to what are called essential health benefits. So even though essential health benefits are only mandated in the small group and individual market, if you're a large employer or self-insured employer and you do offer essential health benefits, then you are subject to that same restriction of being prohibited from imposing annual or lifetime dollar limits on those benefits. So so very limited rule in the post-ACA world, but technically you could have situations where that's not being imposed on EHBs, where annual or lifetime limits are imposed on non-EHB type benefits. The second rule is that there has to be parity with respect to the financial requirements and quantitative treatment limitations. So, for example, financial requirements are things like deductibles, copays, etc. The quantitative treatment limitations are things that are pretty easy to quantify, right? Like numbers of treatments, numbers of doctor visits, the days of your coverage, things like that in the plan. And then there has to also be parity, and this is really the hardest rule for employers to try to understand, and that is that there has to be parity as to non-quantitative treatment limitations. So those are things like medical management standards, formulary design, standards for provider admission to participate in a network, plan methods for determining UCR charges, restrictions based on geographic location. This is where things can get a little bit fuzzy, right? Because maybe your network is a little bit narrower, or has a more limited geographic region on the mental health side than it does for a comparable benefit on the medical surgical side. That's something that you would have to adjust under these mental health parity rules. Okay, so let's talk about some of the other really important rules to understand with mental health parity. One is that these rules do not require your plan to offer mental health or substance use disorder benefits, right? So if you remember from the very beginning of the rule, it said, if you're going to be offering them, then they have to be have parity with the medical surgical benefits, but nothing in there says you have to offer them. And there are some key terms to understand. They use the term group health plans, which just essentially refers to plans that provide medical care. Medical and surgical benefits are defined like you would think. Essentially all medical benefits are not mental health and substance use disorder benefits. And mental health benefits is defined extremely broadly to include everything from psychiatric care benefits to things like eating disorder treatments, which we'll be talking about in a little bit. And substance use disorder benefits is defined very broadly, but can include things like opioid use disorder benefits. some of the key exceptions that are out there to understand are that there's an exception for group health plans that provide only accepted benefits. They're not subject to MEPA and MAPIA, so they don't have to comply. So, for example, your health, pretty much every health FSA today is going to be an accepted benefit. So those don't have to comply. Health FSAs are not going to have to comply, but they rarely limit mental health anyway. Also, employers with less than 50 employees are exempt. There is an opt-out exemption for self-funded non-federal government plans, but that opt-out does require that you make a certification to the Department of Health and Human Services. A lot of employers and sponsors of plans really don't want to do that because they think it's going to bring them a lot of scrutiny, and it certainly could. There's also an increased cost exemption that does require an actuarial analysis to be performed, which technically could be even more costly than the increased cost that you are trying to seek the exemption for. So very rarely used. I've never seen any of our clients ever use the increased cost exemption. One thing to note is there is no exception under the code or the PHSA for church plans. So if you're a church or church-affiliated organization, you still have to comply with mental health parity. Interestingly, there's no penalty for not complying in the regulation. The law and the regulations don't have anything that have any specific statutory penalty. However, participants can sue under ERISA, and agencies can audit for this, and including if the participants can also sue for breach of fiduciary duty under ERISA, so which can have very high penalties for plan fiduciaries. So that is very concerning. Also, there was a recent court decision in 2015 in the Second Circuit Court of Appeals that said that TPAs for self-insured plans can be liable for mental health parity violations. So a lot of things can happen if you're not careful with your mental health plan. And here, just to kind of give you an example, this is a 2016 report to Congress on DOL enforcement activity of the MAPIA, and it shows there the four most common violations. You can see on this chart the number one being the non-quantitative treatment limitations, which, like I said at the very beginning of the section, really have baffled employers and just very hard to understand. And here are some specific examples. This is really just more for your own reference later to take a closer look at. But one example is, for example, a restriction on coverage for chronic behavioral conditions that last longer than 6 months, where there's no restrictions were imposed on medical or surgical benefits like that. So that's the kind of thing that you would see, in most cases where there's going to be penalties imposed, or where individuals and participants are going to sue under ERISA. Now let's talk about our top 5 big developments that we see in this area in the HIPAA and the mental health space. One of the first ones really is the cybersecurity guidance, and this is something that has really taken center stage since the Equifax hack. And while this stuff happened back in June of 2017, it really is there's some just tremendously valuable resources that have been put onto the HHS OCR website to help employers with cybersecurity incidents that may be happening with their plan. The new guidance provides step-by-step instructions for covered entities and business associates to respond to cyber incidents that may lead to HIPAA data breaches, including ransomware attacks. There's also a cyber attack infographic, and there's also these new cybersecurity-related newsletters on their website. We've provided links to all 3 of those things that can be very valuable resources for your organization when you're trying to put together the right HIPAA incident response team and the right kind of HIPAA incident response plan, which we're going to be talking about later as well. The other thing that happened, although it's not technically a development, it's not technically new guidance like the first thing, but we're going to lump it together with the first one, is that there was this new wall of shame that went up in July of 2017 that showed enhanced data about individuals that have had HIPAA breaches, organizations that have had HIPAA breaches, and you can run searches on that and see a much broader spectrum of employers that have had HIPAA breaches that have been required to report. And we've also provided a link to that for you there on this slide, so you can take a look at that, see if your organization is on there, and definitely a great resource, which has been updated recently. We wanted to also focus in today on, as part of our third big thing, and that is we really wanted to focus in on some of the big cases that happened that we find to be particularly valuable for employers that are developing their HIPAA policies and procedures. The first one is a case that a settlement between OCR and an employer. The employer was UMass. It was a university that was operating as a hybrid entity. Occurred about a year ago. But here you had a situation where malware allowed impermissible remote access to the ePHI of 1,670 individuals without firewall protection. And the problem here was that when the OCR did their investigation, they found improper hybridizing within the entity, so that within their policies, they didn't properly designate all the different healthcare components of the organization. That's something that I find to be very relevant, not just to our clients out there that are universities and school systems, but a lot of other large organizations that may have PHI coming in and out of the organizations in places that they're not really thinking about. So, for example, if you are a university like UMass, right, you may have a sports facility that is, has medical records and medical-related treatment PHI in that facility, and you may have a medical research lab within the university that has access to PHI. Those components of your organization need to be taken into account in your larger overarching HIPAA policies and procedures, which is something that really didn't happen here, that they weren't able to really implement any kinds of safeguards because of the fact that they hadn't taken these things into account, which resulted in a very large penalty. Let's also talk about this one that happened with Memorial Healthcare System in February of this year, which was a $5.5 million settlement payment in a 3-year corrective action plan. This one was a very serious. I really like to look at this one as kind of a worst-case scenario in many ways of what can go wrong. And here you had a situation where several employees impermissibly accessed patients' ePHI. The OCR found inadequate security access controls. So, for example, when employees were terminated, the organization didn't terminate the former employees' login credentials, which allowed them to access patient PHI without detection for a year. And then those individuals then went out and sold the PHI of the patients, 14 of which of those employees who sold the PHI were criminally charged. So very bad situation there. There was also a really big one that affected a provider of wireless cardiac monitoring service. They were assessed a $2.5 million penalty and a 2-year corrective action plan after a laptop was stolen from an employee's car with a PHI of 1,391 individuals on it. The OCR found multiple security compliance issues, inadequate risk analysis, inadequate risk management plan, not having policies and procedures for the encryption and movement of hardware and electronic media. And I think that one is just such a strange thing because it's strange to see a provider of medical services to have, of wireless monitoring services to have that kind of disregard for ePHI, and just very strange situation there. And then this last one is a very large civil monetary penalty of $3.2 million assessed against the Children's Medical Center of Dallas. And here again, like the last case, we saw the loss of an unencrypted, non-password protected device at an airport and the theft of an unencrypted laptop from the entity's premises. And this one, like the last case, really remind us, you got to be super careful with those portable devices and laptops. When those things get stolen, or that's when you can have a problem if they're not encrypted. Again, the OCR found inadequate risk management plan, inadequate safeguards, failure to address the risk of unencrypted ePHI, and the fact that they were warned by their consultants, do not have, not to do this, and they had prior incidents and they still did it wrong. So definitely not, if you're going to do the HIPAA trainings, and not only go to the trainings and listen to them, but change your policies and respond accordingly. And just to do a quick plug for our team, that's one of the services that we can provide for your organization. We can do a training for your PHI handlers and your privacy officer on what's required under HIPAA. But of course, you need to still do things to make sure that your organization is being protected. We also just wanted to briefly mention the status of the HIPAA Phase 2 audit program, which we get a lot of questions about. It began back in July of 2016. There were 3 rounds. There were desk audits in round 1. of covered entities. Then there was round 2 desk audits of business associates. So desk audits are just, they're not coming onto your premises, but they're asking you to email them information about your compliance with HIPAA. And then round 3 was supposed to happen last year, but it's been indefinitely delayed. We expect it to happen sometime in early 2018. But the bottom line here, though, however, is that the pace of these HIPAA audits are continuing in full force. There was some expectation that this would be slowed by the Trump administration, but that's really not the case. They're really pushing full force in this area. We also had a couple of things we wanted to mention in our top 5 about mental health. The first was that mental health parity guidance came out in June of 2017 that would apply the same HIPAA rules to eating disorders. It's still proposed guidance, so it was accepting questions and comments. But it's pretty clear that if you have eating disorder treatment in your plan, you have to treat it just like any other kind of mental health parity benefit. So watch those financial cost limitations and treatment limits to make sure they're not more restrictive than the medical and surgical treatment limitations. The department's also issued a draft model form that participants and their representatives could, but would not be required to use, that could be used to request information from their plan or their insurer regarding mental health or substance use disorder benefits, or to obtain documentation after an adverse benefit determination involving mental health or substance use disorder benefits to support an appeal. So that can be very, very helpful, especially now, now that we're in the midst of this opioid epidemic. That can be an extremely helpful resource to have with you. And while this stuff is very helpful, and we always applaud new guidance that clarifies the rules for us on MAPIA and mental health parity, since it's so complicated, we're still seeing a lot of employers that are very, very confused about how to apply the MAPIA rules on non-quantitative treatment limitations, like the geographical limits on the size of the network, things like that. Particularly due to the fact that the costs are so high, there's a larger and larger incentive for employers to try to do things to reduce or to carve out or otherwise restrict or limit the mental health benefits. And speaking of which, our last development in our top 5 is something that happened in 2017. It's a case that came out of the Eastern District of Texas, and it really shows what are some of the implications, right? What can go wrong if you exclude a mental health benefit, if you carve it out of your plan. And in this case, there was an employee. She challenged the exclusion of applied behavioral analysis, or ABA treatment, for her son's autism under her employer-sponsored health plan. When the employee first asked her employer whether the plan covered ABA treatment, she was told the treatment was excluded under certain general plan exclusions, but then subsequently, she found out that the employee was notified. She found out, however, that the employer would be adding a specific exclusion just for ABA treatment. So in other words, she asked the question, and then they carved it out. And the participant sued, claiming that the addition of a specific exclusion shortly after she inquired about it, that constituted prohibited discrimination and retaliation under the Americans with Disabilities Act. Now, she did not, no one alleged here any violations of the mental health parity laws or MAPIA. So this case really didn't involve mental health parity, but it shows what could go wrong, right? If even where you do something like this under the disability laws. So in this case, the court ruled against the employer. The employer tried to do a motion for summary judgment to dismiss the case. The court ruled against the employer, let the case go forward, holding that the ADA prohibits discrimination against employees on the basis of their relationship or association with another individual who has a disability. So the key takeaway here for employers is, be really, really careful before you do one of those carve-outs and you exclude a mental health benefit. The implications can be beyond just the traditional types of rules you might be thinking about, like mental health parity. They can also constitute disability discrimination. So we wanted to, at the end of our presentation here, look at some of the things that your organization can do to protect itself in the event of a HIPAA breach. So some of the big things that that are absolutely essential are to develop a HIPAA incident response plan, which we're going to discuss in just a little bit, to ensure that HIPAA policies and procedures are in place and that they're followed, not just that you do them, but you follow what the policies say, to make sure that your HIPAA business associate agreements are updated and in place with all business associates of the plan, which we'll talk about a little bit more in detail later, and to conduct regular HIPAA training for your privacy officers and PHI handlers. And then on the mental health side, really make sure that your organization is providing that parity between medical, surgical on the one hand, and then on the other hand, mental health, substance use disorder benefits. You really don't want to be tampering with those or doing things to try to reduce cost without first confirming that you can legally do it, and then secondly, confirming that the insurance carrier can do that from an administration standpoint. Sometimes you might want to do something and the insurance carrier really can't administer that. And then of course, definitely get have careful legal review in advance of making a exclusion or limitation on your mental health benefit. You may also want to consult an actuary if it's something that may be a little bit harder to quantify. Okay, so when you're developing a HIPAA incident response plan, how do you make sure you're doing the right, appropriate response plan for your organization? Well, these are some of the things we've outlined as the most significant in that regard. Preparing for a possible breach. It's great to say, okay, well, we've got this great response plan. It covers all the main topics. It checks all the boxes. But what really happens when that breach actually occurs, right? What do you do? What are the actual steps to take? It should say that in there. It should also identify and install the appropriate internal incident response team. Typically, what we see is, in most organizations, that's going to be comprised of the Chief Information Security Officer, the HIPAA Privacy and Security Officer, Chief Human Resources Officer, Chief Legal Officer, and typically a Chief Operations Officer of some kind. Typically make up that incident response team. It can vary somewhat within that, but that's generally what we see. Then you want to line up also the appropriate external support in addition to that team to help them and assist them in the event of an incident occurring. And then you want to conduct a security risk analysis and then update it over time, right? Because computers change, technology changes, make sure it's updated. You also want to have an internal reporting requirement system as well as an external incident response process to make sure that, if you need to highlight the media, if you need to alert the media, who are you alerting? What are you doing to make sure that you're doing the right kinds of external reporting? And finally, of course, you want to make sure that you're reviewing it to make sure it's up to date with current laws and regulations. Really, in light of all of the different things that are happening with cybersecurity incidents on the rise, now is a more important time than ever to really be making sure that your policies and procedures reflect the reality of your organization. And that's something that we, the consultants at Corporate Synergies can really help you and work with you to define and to develop over time as your organization grows. And then finally, we wanted to talk about HIPAA business associate agreements and some of the best practices to do with business associates as an organization. So, of course, one thing you should do is be making sure that you regularly review and update your organization's list of current business associates. Are all of those still fitting with your current operations? Maybe you changed a cloud provider, maybe you've changed certain vendors to your plan that would have access to PHI of your plan. Well, have they signed the new BAAs? Make sure that you have an accurate and current list of those BAAs that work with your plan. You want to develop a comprehensive due diligence process for selecting new service providers for your plan, right? Do you want to have background checks? Do you want to make sure that those people who have access to the PHI would not be able to do anything wrong or sell it or breach your system? And then, of course, you really want to carefully review the form and content of those business associate agreements, right? They are agreements, so you really want to make sure they're consistent, they comply with the law, they reflect your current breach response procedures. You want to make sure you understand in those who's going to be sending the notifications, who prepares the content of the notifications, who pays for notification, is there any kind of, which party will arrange and pay for mitigation? Do you want to have the notification time periods to be shorter than that 60-day regulatory period, that's actually, in my experience, the one that's most commonly negotiated down to a lower time period, typically between anywhere from 5 business days to 2 weeks is kind of what you tend to see in most of these agreements. And then, of course, you want to have procedures in place for the ongoing monitoring of the business associates and the BAAs. And that includes everything from making sure that that over time that they're keeping up with current security protocols, encryption, things like that. You want to constantly be monitoring it. Within our organization, we have a quarterly HIPAA committee, compliance committee meeting, and we take this very, very seriously. So again, given the rise of these cybersecurity incidents, you have to always really be on the lookout for these types of things and make sure that you're staying in compliance in these areas. Okay, so we did want to talk about what we're going to be doing next year for 2018. We're going to be calling it our Benefits Bootcamp, and we're going to be going beyond just legislative and regulatory compliance, and we're going to be adding new topics to our bootcamp designed to improve your organization's bottom line. So that's going to include topics like the benefits of self-insuring, the implications of RX carve-outs, and other topics just like that. So definitely stay tuned for more information on that, and we will be providing it to you. One of the things I wanted to briefly say before I go is that one of the great things that we do here at Corporate Synergies is our compliance assessment, which is a mock audit based on real U.S. Department of Labor audit guidelines. And while we typically cover at least 40 different topics in our standard assessment, often depending on the complexity of your organization and the benefits offerings that you may be offering to your employees, we can often cover over 75 topics or more that are related to your plans, and topics that would come up not just in a DOL audit, but in an IRS audit, HHS audit, or EEOC audit of your plan. So, it's really a great service that we offer to our employees. And in every audit that we've done for our clients, whether it's just whether it's a client of the brokerage or it's a client of the consulting division, and whether it's just a few hundred employees or over 10,000 employees, we've always found at least one area where there's an outstanding liability that we can help you with. And then rather than just kind of pointing out to you where those liabilities are and what those penalties could possibly be, we also then work with you to help resolve each and every one of those liabilities. So whether that's drafting a plan amendment, submitting a delinquent filer on your behalf with the DOL, or helping you to get that non-discrimination testing done, whatever it is, we will go through with you line by line and make sure that all those items that we've identified in your compliance assessment are fully resolved. So what we've done now is that in light of the growing popularity of these compliance assessments or mock audits, we've decided to give you a shortened one for free. It's our compliance pop quiz. It's the top 4 most likely missed, the ones that we see are missed the most often on our assessment, our top 4 questions. And we've allowed you now to take this automated mini assessment, or this pop quiz. If you go to that link, corpsyn.com/quiz, you can actually take our automated mini assessment on our website. So pretty cool, right? Pretty amazing. If you love it, if you learn something, or you want to see it even better, definitely leave us with your comments and your feedback, and we'd absolutely love to hear what you have to say. So that's it for me today. Thanks for joining me, and I look forward to speaking to all of you soon. Have a great day.
Great information, Dan. Thank you. Everyone, before you exit the webinar, please take a moment to download your Sherman HRCI credits by clicking the yellow certification widget. Again, we will send out the presentation slides to all attendees by tomorrow afternoon. Any further questions can be sent to me at dina.beck@corpsyn.com. Thanks for your attention, and please enjoy the rest of your day.